Let me introduce to you Wornie Reed, who I had the privilege of just meeting today, and I am glad I did. Professor Reed is a professor of sociology and Africana studies at Virginia Tech, right down the road. He is also the director of the Race and Social Policy Center at Tech. Among other things, the center conducts original research in the area of public policy with an emphasis on race and ethnicity. Before Tech, Wornie was a professor of Africana Studies and the director of the Africana Studies program at the University of Tennessee in Knoxville. A primary interest of his is, unsurprisingly, race and criminal justice, and also health and race as it affects criminal justice, including the exploding and remarkable issue in criminal law circles of lead poisoning and its role in violent crime. Professor Reed is the author of many books, including the 2011 book, Racial Profiling, Causes and Consequences. He's a graduate of Alabama University, got his master's and his PhD from Boston University. And aside from teaching at Tech, he has taught at the University of Tennessee, at Cleveland State, Morgan State, and Washington University. At Cleveland State, he was a professor of urban studies, and for 10 years, if I have this right, the director of the Urban Child Research Center at Cleveland State. Basically, he's another one of these guys who just can't seem to keep a job, apparently. Or he has cloned himself to be able to do more than what a mortal can possibly do. He serves or has served on or been the chair of or the director or the founder of more boards and organizations than you can shake a stick at, many dealing with issues of race and health, many dealing with issues of the welfare of children and preventing youth violence, and many dealing with the issue of minority incarceration. He's authored scores of chapters in books on race and health and found time to win 2 regional Emmys for his work with public health television. It's a pleasure, beyond description, to have him here with us today.
Thank you very much for those kind words. They were really too kind, because he made me, on the one hand, my age, but also he made me younger than I am. When I went to undergraduate school, I could not have gone to the University of Alabama. I went to Alabama State, a historically black school in Montgomery, Alabama. And I might as well have admitted that to you, because you would have started calculating something about how long I've been around when I tell you that I participated. Unlike John, I managed to make it to the 1963 March on Washington. And I participated in a number of events that Martin Luther King led, including the Poor People's Campaign, which was his major emphasis, whether you know it or not, at the time of his death. The Memphis garbage strikers work was kind of a side trip, and he was involved in many things. But the major thing was the Poor People's Campaign, where he was intending to enlist everybody who would join him in calling attention to this issue by occupying D.C. Now, it may surprise some of you. I didn't plan to say this when I stood up, but here's what he said. We will beseech our government to do something about poverty in the country. And we will go to Washington and we'll stay until they do. And if necessary, we will close it down. And that's new to some of you. And I better stop there. I'm going to be giving a talk next week about reclaiming the Martin Luther King I knew. Because the one we celebrate a lot around the country today is an imposter. He's not the person I knew, but that's not what I'm supposed to be talking about today. What I'm going to talk about today is to talk about something some reason why we need to reclaim him. Because if we were to reclaim him the way he did things, we would address these issues. So I don't have anything else good to say. Everything from now on is going to be bad. And so therefore you'll be glad when I finish. Let me see, I need to, okay. I'm going to talk about race and sentencing in juvenile courts. Now, they don't use that term sentencing in juvenile courts, but I'm going to use it with you because you may be more familiar with that term. They call it final disposition, the outcomes. They just don't like to use these adult terms in juvenile justice. So what I want to show you now is the way that this was looked at a long time ago. You had legal variables. These are the things that were supposed to determine whether or not you were sentenced or whether or not you were put in some confined place. So one of these is the prior record. That is, how many times have you been referred to court, or to the juvenile court? What's going on here? Okay, well, we got to get this better, I guess. Things are going backwards for me. Okay, now the next one is offense type. I was hitting the left side. And those are the two legal variables that should count the most for determining whether or not a youth is going to be, I'm going to call it, incarcerated. They don't use that term in juvenile courts. However, 30, 40 years ago, we would look at extra legal variables as well. These are social variables like race and gender. So this is the way things were done before. We would look at this, but what happened is some of us were involved in the early 1980s in looking at some other things that affected whether or not a juvenile is incarcerated. That is, I'm just going to jump to the bottom line. And one of these was detention, the detention decision. There are some process variables, some process points in the juvenile court that have a lot to do with what happens later in the proceedings. One of them is the detention decision. The detention decision is whether or not a youth is held in a pre-adjudicatory phase of the process. I'm using one of your terms. The next one is the screening decision. The screening decision really means the manner of handling. How is the youth handled? Is it formal or is it informal? Well, that makes a lot of difference, because if it's handled informally, then this person cannot be sentenced to secure detention as an outcome. And so these are the process variables. So a colleague and I added this to the literature of what we should be looking at in addressing the issue of whether or not there are racial disparities in juvenile courts. And so this is the conceptual framework that we introduced back in the 1980s. Okay, that we look at those legal variables, we look at those social variables, but we also look at detention decision, screening decision, and final disposition. So when we looked at this data, we found that whether or not a youth is detained before there's a hearing determines to a substantial degree whether or not the screening decision is going to be formal or informal. Oh, and I might tell you that we were analyzing data from across the country, from some 12 states and major jurisdictions that had begun to submit their data to the Office of Juvenile Justice and Delinquency Prevention in the Department of Justice. The screening decision, that is the manner of handling, determines to a large extent, sometimes, but sometimes not, the final disposition. So these are the kind of things we were finding. We found that blacks had much more pre-adjudicatory detention. That is, black youth were held before a hearing overnight in secure detention much more often than white youth. Blacks tended to be handled formally. In the screening decision, it would be a formal process, which meant, if you're familiar with the juvenile courts, that there would be a petition filed. Good. And of course, what we were all looking at during that time and ever since is whether or not African American youth received more, proportionately more severe dispositions. And the key one that you would look at is whether or not they got secure detention in a youth facility. So recently, we've applied this model to Tennessee. So I just jumped in those few seconds 30 years. So in the 1980s, we found what I just showed you in the previous chart. So now, what we find now in Tennessee, looking at the year 2006, where we looked at all cases of youth appearing before juvenile court in Tennessee, over 132,000 cases. Same thing. Blacks were detained 3 times the rates of whites in the pre-adjudicatory process. That is, before any hearing. Said, well, this youth we should not let back on the street. Let's hold them until we decide what to do. That is, to hear a hearing, to have a hearing and what we would call, for adults, a trial. Blacks, in 2006, in Tennessee, were handled formally 17% more often than whites. What that meant is that there was a trial, or hearing, a formal hearing for juveniles in the juvenile court, 17% more often for blacks than for whites. Remember now, if you handle informally, you cannot be sentenced to a juvenile facility. So whites were handled informally more often, 2006. And of course, blacks receive more severe dispositions. That is, they were sentenced to secure detention more often, 20% more often. We're just beginning to look at Virginia data. So I don't have the same level of analysis there, but I do have analysis from the group data. Just to show you what, and I would like to ask you, what do you expect our data to show after I show you this chart? Okay. Don't try to read all the numbers. I'll just look at the third line, cases involving secure detention. That is detention before a hearing. What that line says is that black youth in Virginia in the year 2010 were 80% more likely to be held in secure detention before a hearing. Okay. Remember now, if you're held in secure detention before a hearing, then you're more likely to get a severe disposition. And in Tennessee, cases diverted, where those that get diverted are brought to the court and diverted before the detention decision is made. Blacks are 10% less likely to be diverted from court. And we have the same data, cases resulting in delinquent findings. That's juvenile talk for kids found guilty and who are put in secure detention. They're 20% more likely. The same data we found for Tennessee in 2006. 20%, blacks are 20% more likely to be sentenced to prison. And the bottom line, cases resulting in probation placement. Blacks are 10% less in 2010 in Virginia to get probation. That is, the final disposition is to give them probation rather than put them in a facility or something else. So, what do we conclude from this? I just have a couple ones, and you may have others. One, racial differentials in juvenile court processing has continued through the decades. Despite all of this talk about things getting better, they're not. In fact, in the criminal justice system, I would argue it's getting worse, but in the juvenile system, it's certainly not getting any better. And it raises a question about the viability or the continued viability of juvenile courts having discretion. Discretion has always been, as I understand it, an aspect of the juvenile court, where some things are left up to the discretion of the officials, the judges and the others, rather than abiding by any strict law. Because they said these people will know better what to do with you. It seems as if we have the same conclusion nowadays that we had back in the 80s and that we proposed, is that the issue of discretion be looked at and examined. Is this something that should continue? I'm not sure. I kind of side with the fact that it should probably not be continued unless there's some very good arguments for continuing, and we can find some other ways to reduce this disparity, this racial disparity in juvenile courts. Thank you.